Hi, Leslie. I've just admitted Keith.
Okay, so we can get going. All right. So welcome everyone. This is our School of Public Health and Family Medicine weekly noon meeting. For those of you who don't know, I'm Leslie London. I'm in the Division of Public Health Medicine, but work also in occupational and environmental health. And we're very pleased to have some really interesting speakers today to talk about a topic which is a topic around social justice and environmental justice. As we know, South Africa has seen a number of court cases where settlements have been made awarding compensation through court-mandated trusts as vehicles for compensation for occupational disease in South Africa, partly the result of the failure of our compensation systems in the country. And in September last year, the journal Occupational Health Southern Africa published a very interesting commentary, a critical examination of this phenomenon published by Dr. Albert Mushai, who's joined us, and his collaborator, Professor Robert Vivian from the WITS School of Economic and Business Sciences. So that commentary really raised questions about the nature of the settlement and the sustainability and the value, and asked some important questions we need to answer. So in a sense, responding to that, we have Richard Spoor, who's an attorney who's been very involved with a number of the cases which have brought compensation for mine workers here as well. We're very pleased that Richard's been able to join us. And also Professor Keith Breckenridge from the WITS Institute for Social and Economic Research, who has also looked at questions of health and safety in the mining industry and the social construction of the systems we have to address that. So the way it's going to work is we're going to ask Professor Vivian and Dr. Mushai to go first, have about 50 minutes just to set out the arguments. Richard Spoor will respond, and then Prof. Breckenridge will do a third input, and we'll keep questions and comments for afterwards. We've extended this new meeting beyond 1 o'clock. Normally it ends at 1, but we'll go on till 1:30, just that we have enough time for proper discussion. So without further ado, can I ask everyone who's not speaking to mute their microphones, and then hand over to Richard and Albert. I'm not sure who's going to speak first, but over to you.
Okay, I'm going to just try and share my screen just to put a PowerPoint presentation up. Let's see if that works. I hope so, otherwise I won't know how to speak. So just give me 1 minute.
Yes, good.
Okay, has it appeared?
It's appeared, yeah. It's appeared.
Okay, then let me start. I want to say that having read Richard Spoor's comment, I don't think there's much difference between the two views. I think the views are similar in principle, but very different in detail, as will become clear. There was some difficulty on getting hold of Albert because he was tied up with a whole lot of other things, but managed to get hold of me, and I managed to get hold of Albert. And so what I offered is I would sort of go through Albert's argument, because I'm quite familiar with the argument. It's part of his PhD, and I supervised that PhD. And then I said I would also see if I can locate Albert. Nowadays with the lockdown, it's not always that easy, and I'm delighted to say that I managed to locate him. And he's, yeah, so what I will do, I'll do the presentation. I think when it comes to question time, I'm sure you can field most of the sort of questions, but I will do the presentation. And I think the outcome will see that I think in principle there's not all that much difference. It's just a detail, which is, okay, now. Right, so we're really talking about compensation for occupational diseases, so let's look at that in a context. It was decided about 100 years ago, employees who contract occupational diseases should be compensated. Basically a decision around the world. I have an idea, looking at the history, South Africa might have led that argument, because the argument prior to that was just occupational injuries, and diseases always lagged end of it. Okay, so the compensation for occupational accidents came at the end of quite a lengthy process, and that process is quite important if we want to go forward, and putting it in the context of where we want to go forward. The original attempts was to do what has now been tried again, and that is to go and sue individual employers through the law of torts, South Africa, the law of delict, and the courts over judges from 1834 to 1900 came to the conclusion that it simply was not a system that was suited for it. What you really want to do is to give people compensation. So you should focus on the compensation. And economists and economic arguments also started to arise, and they were quite good. And that is the cost of occupational diseases is really being imposed on innocent parties. And those innocent parties is not necessarily the injured party, but also the families that that party was supporting, and now you cannot support the medical costs which have to be paid, and you can't pay it, and how to support those sort of families. So from an economic perspective, roundabout at the same time, it was realized that there are activities which take place which impose costs on innocent parties, and that it was best that these costs get internalized and a way be found to compensate for it. So there is an economic argument and an economic analysis, which is what Dr. Mushai based his argument from. I have indicated to him I don't think that he'd done that clear enough, and I thought that a separate article explaining this and the historical development would be in order. By the turn of the century, it was recognized that the cost of compensation was a cost of production. The expression which was used at the time is the blood of the injured is to be included in the price of the product. So we should put up a system which ensures that people who get injured get compensation for that. As I say, starting at 1900 in South Africa, and it was really the subject matter of a thesis in South Africa by Elaine Katz called The White Death, which showed how the occupational diseases component became involved. So it was recognized that we need a system that says that if a person gets injured, then that person should get compensated. And so that's a system which was put into place 100 years ago. So the idea that a person who contracts an occupational disease needs to go to court and spend now over 10 years in that case is rather strange, because the system was designed to give compensation without all of that process which is involved. Okay, so then the workers' compensation evolved, and the workers' compensation does exactly what the economist argues it should do. It internalizes the external costs, and the system is therefore correct for the purpose of providing compensation. What happens, the employer pays the average cost of compensation, which is the levy, into the fund. The fund then pays the compensation. The fund also builds up all the expertise necessary to deal with these problems. Individual employees who, if we didn't have the fund, they would have to get that expertise themselves, and that would not really be possible. So it's a win-win situation. The employer deals with and faces no other obligation. Now that's really quite an important point, because the idea was once the costs are being internalized, then the employer faces no further financial obligations. The financial obligations dealt with through the fund, and if there is a problem and the fund does not have enough money, the fund would have to come back to the employer. So the system was there to be able to do that. There was no idea that the judiciary and the judicial system should be further involved in the system. Obligations are all dealt with by the fund. Now, at that point, you can see we've separated two things. We've separated the funding from the preventative measures, and the preventative measures are then dealt with in terms of the Mine Safety Act. So there's an entire different system which is aimed to make sure that injuries don't happen, people don't get occupational diseases, protective equipment is built, and that again is funded by the employer. So the occupational system and the preventative measures are all funded by the employer. It's not that the employer doesn't pay anything, goes away, walks away free. That's not what happens. Now, the trust system, which is what has evolved and is evolving, and it's evolved in other parts of the world, as Dr. Mushai has indicated, we could say that is the law of delict plus the trust system. Now, that is the issue which the courts over a 100-year period have looked at and dealt with a large number of cases. And not only them, the jurists and also the economists by 1900 come to the conclusion that the judicial system is not suited for dealing with occupational matters. As Mr. Spoor himself points out, and he's quite right on this, the system cannot deal with 400,000 individual cases, taking each of these cases, looking at the merits of each of these cases, and all the individual things which an individual court case could have. So it cannot really deal with matters which happened 30 years ago. In many cases, in the case of occupational diseases, we'd have to argue that the firm was negligent, and when was this negligent? It was when they were working, and they didn't use protective equipment and all the rest, which was 30 years ago. And simply can't get evidence to do. So you're going to force the judicial system in to do something which it can't do. So what happens, and it has always happened, and it happened in this case as well, the courts actually never make a decision. So the end of it you say is, okay, what we'll do is we'll settle this now by paying a capital sum into the trust, or having a commitment to pay the sum into the trust, which is probably a lot more centered. Then the fund has to set up rules. As we know, it's now taken several years after the agreement was signed up to work these rules out, and there's some criticism at the moment at the length which is taken. I have a great deal of sympathy for the fund because it does take a long time to do that. So if we have a lump sum of money, some rules, people with the expertise, what have we got? Well, we simply got another workers' compensation fund. We simply created a second fund, and workers' compensation is dead, we can say. Long live workers' compensation. So the delict and the trust system is not a different system. It's simply another workers' compensation system. So what we do is we create another bureaucracy, and once again, paid for by the employer. So the employer is paid originally to pay for the compensation. He's paid with a mine safety system to prevent the losses, and that was supposed to be the end of his obligation, and now he has to pay again. And as Dr. Mushai correctly points out in his article, the employer paying today is not the employer which was involved 30 years ago. So different shareholders, different circumstances, different structures. So another economic analysis which has been carried out, which indicates the wrong person which is paying. So it would be much better if we simply had a single system which operated without any problems. So what is the way forward? The trust system does not fix the system. You say, why is it that we had to go down the law of delict and the trust? Well, the argument is the system is broken. And we can argue the system is broken. Well, the trust system does absolutely nothing to fix that system. So to the extent that it was broken and the extent that people are not getting compensation or adequate compensation, well, that doesn't change. Some people, a very small number of people are going to get a benefit, but until you fix the system itself, you haven't really solved the problem. So employees with compensation receive inadequate compensation, which is the original argument. Unlike other cases, this is not an argument they did not receive compensation. They did receive compensation, but it was inadequate compensation. Well, the solution to that is that we should simply fix the system. Having a second workers' compensation fund does not fix that particular problem. Now, if the fund is not working, then one can argue we should look at the operational fund, which is a special fund in this case, the Occupational Diseases in Mines Fund, not the General Workers' Compensation Fund, and we should have a fix it. And then people would say, well, yeah, that's a government fund. So if that is the case, and we're looking at government failure, and the government failure should not be imputed to the private sector. So one can't say the private sector failed, they didn't provide compensation, they funded the system, they're funding the second workers' compensation system. It's a government failure. Now, on the position of government failure, I think that we might have a slightly different perspective than what others. We think that it's a government system, it's not working, we shouldn't just stand back and criticize them. We should get together and work with the government to get the system to work. So we shouldn't just stand on the outside. We should also not even worry about trying to sue them all the time. We should simply say, let us get around the table, let's work out what's not working, and let's then get the system to work. There is no other system. Trust plus delict plus trust is not a system which is a viable alternative to the workers' compensation fund. So we should put some effort into fixing the system and making it go forward. Problems with the trust. A lot of the paper by Dr. Mushai, in fact, most of it is looking at the problems around the world with the trust. So the trust system simply has not turned out to be a panacea for the problem. And one would not think it is, because there is a solution. We have to make that a type of solution. So the whole host of problems which exist, they were set out by Mushai and Crosley in the article. One of the funds which we have is the Asbestos Relief Trust Fund. It started with 401 million rand. It still has 243 million rand. So it didn't pay out all the claims which was, or didn't pay out all the amounts which it was anticipated. In 220, it paid out 27 millions, and it had 125 claimants. Now, I put in brackets a figure which one can compare the 125 with, say, occupational accidents. There's about 250,000 claims against the Workers' Compensation Fund every year. So you can see the 125 is quite a small figure in comparison. But much more concern is to pay out 27 million. The administrative costs were 11 million. So it's about half. So for every rand that an injured person gets, you have to pay another rand, another 50 cents, or half that amount in administrative costs. Now, with economies of scale, if you take the workers' compensation, which pays out 250,000 claims, compensation, the administrative costs can become much lower than that. The dealing plus trust is not an economical system to be able to do that. So I think that's all that I have to say. As I say, I'm quite delighted to note that Dr. Mushai has joined us. So when we get to the question stage, maybe Dr. Mushai would like to make a contribution to answering the questions. Thanks a lot.
Okay, thanks so much, Prof. Vivian. Richard Spoor, do you want to pick up on that and share your views? I know that you published something with Jim Tavatanodi, and the floor is yours.
Yes, thank you for the invitation. I appreciate the opportunity. As Robert Vivian has explained, we're not completely at odds, and we agree on something fairly fundamental, and that is that the civil law compensation structures that we put in place, the trusts over the last years, are not an alternative to an effective and just workers' compensation system. If we had an effective and just compensation that adequately compensated workers for occupational injuries and diseases, there would be no necessity for this type of litigation. The litigation that we've undertaken has been primarily to recover the shortfall between the statutory benefits to workers to which workers are entitled and their actual common law damages. Now, the gulf between these is enormous and has been growing over the years. I'm not going to go into the small detail of it, perhaps in the answers, but in many instances, the compensation that's afforded sick and injured miners and workers generally is derisory and doesn't come close to a reasonable approximation of the actual loss and harm that they've suffered, which means in effect that by undercompensating workers, you are subsidizing continued neglect of health and safety in the workplace, to the extent that employers are not held liable for the full cost of the harm that they do. That cost gets passed on to workers and their families, and in the context of gold, even their communities. Entire countries, in fact, bear the cost. So it's worth looking at where the workers' compensation regime comes from. Many writers refer to a historic compromise, an agreement that was struck between labour, capital, and the state, in terms of which the problem of uncompensated workers and the challenges that they had proving their claims under the law of delict reached to a settlement where it was agreed that there was a bargain struck, that the state would establish a statutory scheme to compensate sick and injured workers. Workers would enjoy the benefit of not having to demonstrate fault, so they wouldn't have to prove negligence. It was a no-fault system. They were guaranteed payment. They weren't faced with the problem of employers going bankrupt in the face of civil claims, but the compromise was significantly discounted damages. Now, that compromise, and the compromise that was struck a long time ago, is a dynamic compromise. It moves. In countries around the world, you find the compensation legislation is reformed and adjusted, and it shifts and moves backwards and forwards according to the relative power of these parties to this bargain and to this compromise. So there have been times when the compensation afforded workers in South Africa was pretty good. An interesting example is the Adimwa benefits, which peaked in terms of real value around about 1947, when the Nationalist Party was challenging for power to remove I think it was the United Party at the time. And the benefits that were awarded to the widows of white miners and to sick mine workers were substantial. There were pensions, there were land scheme grants, there were university scholarships for their kids. It was very significant, and it may well have been deemed to be fair. But over the years, and as the power of white organized labor declined, the value of those benefits declined further. Post 1994, the benefits were ostensibly deracialized and made equal across the board. But what this really has translated into is a massive and significant decline in the value of the benefits that are awarded under the Adimwa scheme. To the point where the benefits awarded now are a fraction of what were being awarded in the early 1990s and 1980s. Now, there's another reason. So the first thing is this political bargain shifts and moves and changes. In South Africa, it shifted very strongly against workers over the years. But there's another thing. This bargain was predicated on certain concepts of law, and in particular, as Robert has alluded to, the notion that it's extremely difficult to prove a claim for negligence. It's expensive for a worker to do it. There are all kinds of problems. He made the point about how do you prove negligence in cases involving delicts or wrongs that were committed perhaps decades ago, which is often the case when we're dealing with dust-related lung diseases. But the law has developed, and our concepts of health and safety and our concepts of an employer's responsibilities have changed very dramatically over the last several decades. So one of the most important shifts, and I think the best way to illustrate it, because people are so familiar with the concept, is this polluter pays principle. So the polluter pays principle, which we're all aware of, is basically something to the effect that businesses, corporations are not entitled to pass on the cost, the environmental and social cost associated with their activities onto the broader community. They must internalize those costs, and they must be held responsible for those costs. So this means that if a tank or a dam bursts and harm is caused, the question is not, was the company negligent or not? The question is simply, was the company responsible for this harm? And if so, they're held liable to compensate for that harm. And it's not based on fault. It could be caused by an earthquake, a lightning strike, any kind of act of God. But the principle that has become entrenched in our environmental legislation is that the polluter pays. You're liable for whatever harm you do. Now, occupational injuries and diseases are not much different from environmental harm. It's another form of harm, but it's also something that's pretty much inevitable. If you've got 1,000 men operating 1,000 power saws, 10 hours a day, 200 days per year, some of them are going to cut their hands off. If you have a chemical plant, you have a mine, you will, with the best effort in the world, you will generate disease, you will generate injuries, and you will kill people. It's statistically inevitable. So the principle is the same. It shouldn't really be whether they were negligent or not. Injuries, disease, and death are a normal consequence. It's part of doing business. The idea that all injury and all disease can be prevented, conceptually, yes, but in practice, no, because invariably it involves a compromise and a balance, which is very much in the hands of the employer. The employer decides how much effort, how much cost, how much resources to allocate to create a safe and healthy work environment. I gave an example of kind of woodworkers who use power saws and who cut themselves. Well, at the moment, there is a technology available called saw stop. Now, saw stop could be fitted to all the woodworking machines in the country. It's an expensive device, but in effect what it does, it stops workers cutting themselves with saws. The moment your body touches the saw, the blade, a brake clicks in and it stops. And it's the same for most anything. Any type of risk can be mitigated or eliminated entirely, but at very, very substantial cost. Who makes these choices? Well, it's the employer who does, and it's therefore only right that the employer should be responsible for the consequences that flow from those decisions and those balances. The other thing, of course, that these principles have been slowly being adapted by the law, and and brought on board in the law. So what has happened is it's become a lot easier to prove negligence. It's not the case that it used to be, where there's a kind of a very mechanical, very conservative approach to these things. I think the high watermark in our law at the moment is the case of Lee versus the Minister of Correctional Services. Lee, it's a constitutional court decision. Lee contracted tuberculosis after having been imprisoned, and he sued the minister on the grounds that the prison service hadn't taken effective measures to protect him against contracting tuberculosis, and therefore should be held liable. The problem for Lee, of course, is that it's impossible to prove that where he contracted the TB. It could have been outside the prison, it could have been a visitor to the prison, it could have been a whole range of issues that could have led to his contracting the TB. So a kind of a conventional approach to the law of delict, you'd have to rule, terribly sorry, Mr. Lee, that while the systems in place at the prison to regulate and control the risk of contracting TB while those systems may have been deficient, you're unable to demonstrate and prove that it was that negligence and that failure to comply that led to your contracting the disease. Therefore, your case must be dismissed. Now, in a minority judgment from Cameron, but which is very, very persuasive, he turns the thing around. He says, look, the question is, did you take reasonable steps to mitigate the risk of people contracting these injuries, contracting tuberculosis? And to the extent that they did not take reasonable measures to mitigate risk, they are liable for the harm that flows from the risk, the increased risk that they created. So in the litigation that we're pursuing now against the coal mining industry, we're doing something very similar. So we're dealing with workers who've been sick, have been exposed to dust over last several decades. Where our focus is, and this is also quite significant, that the philosophy about managing health and safety in the workplace changed in the 1970s from a strict regulatory system where there were rules that needed to be complied to a risk management system. And that risk management system was adopted and became part of our law quite late in the process, but in the 1990s. But it's been around since at least the 70s and was adopted by countries across the world, beginning in the Scandinavian countries, but has spread. And now the focus is, we don't tell employers what to do. We don't tell you how to run your chemical refinery. We don't tell you how to run your mine. What we do is expect you to put in place systems that control, mitigate risk. So it begins with risk assessments, but it also involves a process whereby if you have an incident, an accident or a disease, you investigate it, you identify the cause of the thing, and you take steps to mitigate that risk. Every case gets investigated and dealt with. You also monitor things like dust levels, and if you see excursions going really high, you investigate those, you take steps, you measure them. Now, what we've noted is that these systems that are spelled out in the legislation are not being followed. So if you look at dust levels on the mines, you see wild excursions. you don't see that as being controlled. You don't see a system that is actually working. When you inquire into investigations done into these excursions or particular incidents involving workers who've been identified with lung disease, we don't see that system being applied. We don't see a proper investigation, conclusions, recommendations, implementation, monitoring, that cycle, which is part of the system. So our argument these days is not that you didn't have the right ventilator, that the airspeed wasn't correct, that you weren't monitoring the dust or the cutters were not correct. What we're looking at is your system. And to the extent that we're able to demonstrate that there are systemic failures, in particular systemic failures of the safety management system, that creates an increased risk for workers, and that employers are then liable for the harm that flows from that increased risk. And it is so that largely because of the statutory compensation system, the law in South Africa lags far behind the law in the rest of the world. So the law doesn't develop because it's never litigated. There are no cases where workers sue their employers. There are a handful over the years, and the scope for that has been extremely limited to date. So this impacts on the bargain. So the bargain was predicated on a notion of law and a notion about health and safety, which is fundamentally different to our modern conceptions and understandings of what it means to control and create a safe and healthy work environment, and also what it takes to establish liability, responsibility on the part of an employer. So it's become easier to do so. But that would mean that this bargain shifts. And so there's no need anymore to discount the damages paid to workers. The damages should now come closer and, in our view, approximate the actual harm. I mean, there's no reason why workers' damages should be discounted because the common law of 100 years ago was very unfavorable. That balance has shifted, but what we see is that there's a rigidity in the system. I mean, our COIDA Act, you know, it dates back effectively to about 1947. We still assess damages by reference to a meat chart. I think it's Schedule 3 to the Act. It's a meat chart. It says, if you lose a thumb, that's 15%. If you lose an eye, it's 30%. If you lose hearing, both hearing, complete hearing, it's 50%. It's bizarre. It has bizarre consequences. So a very typical case we encounter is a mine worker. He's injured in a rock fall, he breaks his femur, it heals poorly, he's left with a profound limp and pain and damaged joints. Well, he will be assessed under the COIDA system as perhaps 9, 10, 12% disabled with this profound limp. He will be disqualified for work underground because he's a physical worker and he cannot do this job anymore. He will lose his job and he'll never work again in his life. But he's assessed as 12% disabled. Contrast that with the position of a manager or an engineer who breaks a leg. Well, you know, that's bad, but even with a profound limp, he can continue working. He doesn't lose his job. Think of a bus driver who loses an eye. Think of an artisan who loses a finger or a thumb or a chronic rotator cuff injury. They lose their jobs, their livelihoods, their ability to support their families, and the law just doesn't make provision to adequately compensate them. So we know where these problems lie, but unfortunately there is little appetite to reform these systems. This is in part due to the fact that the systems themselves are poorly understood. It's opaque. The state has lost a lot of knowledge with the changes that have happened the last 20 years. And I think generally levels of understanding about how the system works and how it disadvantages people is not adequately understood. Plus, of course, the people who are disadvantaged by the system are injured workers and their widows. And these people are marginalized, have very little political voice, and aren't an effective political, they don't have a political voice and they're not in a position to change these things. It doesn't trouble employers to change it. because the system suits them. They end up paying only a fraction of the harm that they actually do. And so this suits them well. It's interesting that our litigation has triggered the most lively discussion about reform, but the proposals are weak. For example, a suggestion to merge the Adimwa and Koida funds to put them together into a single fund and equalize the benefits, because Adimwa is so poor. But as Dr. Mushai has pointed out, there's a massive difference between short-term insurance for injuries that occur here and now, and where your levies are based on your risk, your claims history, and compensation schemes for occupational diseases that develop, have very long latencies and develop over years. So when it comes to reform, we agree 100% that what we need to do is reform the statutory compensation system. But first, there needs to be a will and the awareness to undertake that mammoth task. There are continual small efforts to change it. There are amendments to laws. There's a move towards opening up the field so that Rand Mutual doesn't have to stay a mutual association, and there's a move to bring in private insurers, which may have some benefits. But we believe very strongly that piecemeal reforms are not going to solve the problem. We need to do what has been proposed by Robert, that we need to pull people together. We need to have a workshop. We need to have a look what is best practice. We need to look at how we can design and build a reformed compensation system that achieves the basic objects of these, which is to ensure that workers who through no fault of their own are injured, diseased, or killed, that they and their families don't suffer unduly, that there's social support for them, and secondly, to incentivize employers to take appropriate measures to mitigate this risk and keep that cost down. That's not happening. Neither of those objectives are being achieved by the regime today. So our litigation, if anything, is a spur to it, and to the extent that it puts employers on their guard. And I should add, we are endlessly looking for different ways, newer ways to get around the prohibition on suing employers, to make the cost of occupational injuries and diseases higher, and to ensure fairer compensation for workers. The record of the ART is, and the other trusts that certainly I've been involved in setting up, has been good. What isn't mentioned, yes, the ART was funded. I think the funding capital was about 450 million, but we've spent well over 500 million rand, paid 500 million rand in compensation. We do a lot to fund occupational health surveillance in these areas. We provide palliative care to people who are dying of asbestos-related cancers and other cancers as well. And we've done a lot to raise awareness in the communities of the hazards posed by asbestos. It's early days for the Chiamiso Trust, but things are looking promising. We are building a pipeline, and although it's been a mammoth task to get the thing going, I do believe that the target of paying out 5 billion rands over the next 10 years is well within our reach. And I really hope that we'll do that and a lot more over the years to come. And that will help in some small and modest way to undo and provide redress for the enormous harm that workers have suffered. And let's be clear on this, through a callous lack of regard for the health of workers. This was a system designed to ensure that employers didn't pay the price associated with poor health and safety conditions underground. And to the extent that this helps bring about improved health and safety in the workplace, on that basis alone, I think it should be judged a success. Thank you.
Thanks so much, Richard. We're going to move on to the last speaker. So those of you with questions, there's a bit of an echo here. Those of you who have questions, could you just hold them? May I see your hand up? If you could just hold that. The last speaker is Keith Breckenridge.
I don't have a question, I just have a comment. I'll wait until the end. Yeah.
Yeah, just hold it. So I want to introduce Keith Breckenridge from WITS, a professor of cultural and economic history who's written extensively about the mines and particularly gold mining, who's going to finish the last input, and then we'll open it for discussion. So over to you, Prof. Breckenridge.
Thanks, Leslie. I'm going to try and share my screen. If it doesn't work, then I don't know if people are seeing it. I'll just speak to it otherwise. I think, I find this very interesting, and I'm a historian, so I'm a little anxious about stepping into the contemporary debate. I do think the key issue is that the system is not quite as Richard describes it. I mean, it's institutionally much more capacious and systematic in its coverage over a much longer period than most people are aware. So the key issue is that the system that the mines were funding was paying out compensation, I would say, to 2% of the underground workforce from 1947. And it seems to fall to pieces. And the reasoning for that, why that happened, I think is really important. I don't have the answers. But there are several points that I think people really need to hold on to, is that there's a really rich, what we call public infrastructure associated with this compensation system. It is well funded. It's not rich. It's certainly not, So what happens is the acts that make compensation, specify compensation to Africans are revised every decade. So there's one in 46, 56, and there's another one in 73. And when these acts are passed, the compensation is much more generous than it is a decade later. And that's because the inflation, that's rampant in South Africa weakens the body of the payment. So just to give you an example, if you were getting a TB payment in 1973, you got a 600 Rand lump sum payment as an African worker. If you were getting pneumoconiosis compensation, you got 1,000 Rand. 1,000 Rand in 1973 is a much larger sum than it was at the end of the 1970s, and the compensation system never really keeps the sort of stipulated compensation amounts didn't keep up with the value of wages. So the other thing that's happening, it's not just inflation. The union is getting more and more powerful. Workers are getting more and more powerful, and there's a really dramatic increase in African wages in that period after 1973. So let me just kind of, I'm going to just touch on. I gave a much longer talk on this, and I can't possibly address all the things. The first point is to push back against Richard's idea that the mining industry has got away without paying for the costs of production in South Africa. And it's really important for people to understand the tax system that was applied to mining, especially before 1990. This is not true after 1990, where the Nats discover neoliberalism with a great enthusiasm. In fact, it changes after 83 in important ways. So the mines are taxed in the 30s at 50% of profits. By the 70s, the profitable mines are paying 70% of profits direct to the central government, and unprofitable mines are subsidized by the others as units. They don't exist in corporations. They exist as individual entities, and the least profitable mines are encouraged to remain in business by essentially adjusting the tax burden. So the more profitable your mine was, the larger. It was an exponential rate above a certain level, about 8.5%. And it's important for South Africans to realize what that means. Richard's describing a world in which of what we could call natural justice as it's applied to individuals, but this is a system that worked as economically for a much wider group of people. It kept the towns on the Highveld alive. It kept the secondary industries that supported those mines alive, and it provided massive amounts of employment to huge numbers of people. And so there's the liability that rests on underground, especially gold mining, is a liability that is applied to the society. We all owe it. The riches that were generated by this industry were applied very widely. And we can get into the details of how that was distributed racially, but it was a damn sight better than the system we're currently dealing with where we have 50% adult unemployment, right? And we can continue to think about how that system worked, but in many respects it worked particularly well as a way of keeping the broader economy functioning. right? So the mining industry, in many respects, was paying for that. I've said the degree of the compensation is much more systematic than people think. So there are about 4,500 people after 1947. About 4,500 underground workers were getting these payments every year. I mean, of course, I agree that payments were nowhere near what they should have been. But the most important point, and this is important for the discussion of what the trusts will do, is that people were being paid every year and there was no delay, right? So you were getting your cash payment if you came from Mozambique or Lesotho and you took it away with you. You didn't have to find somebody when you've gone home who's going to communicate with somebody in Johannesburg. There was a kind of carceral quality to this. It was like a prison, but it functioned actually systematically. I'll answer questions on this if we have. That develops a rich, dense infrastructure of scientific research, which distinguishes the South African occupational health medicine. It makes it in many ways a kind of global leader. I used in the talk the example of the Pathhout autopsy database that's developed in 1973 at the NIOH. But you shouldn't underestimate how important this whole infrastructure is for the other body of institutions that exist in South Africa. All our medical institutions in the universities, they derive in some way, more or less directly, to this mine infrastructure and the things that it funded, right? The same is true. So people often say, there was nothing in the countryside. There was a void in the countryside. The mines took no responsibility for disease in the countryside. Well, that's also not true. The mines funded the mission infrastructure. So 10 hospitals in the Transkei were being paid out of the Deferred Pay Compensation Fund. And the mines always said, if the state will actually address rural health properly, we'll fund this. Of course, nobody would actually bite the bullet. But the Nats did do more than people are prepared to acknowledge. They nationalized these mission hospitals in the early 70s. And there's no question that rural health actually functioned relatively well historically between the late 1960s and the late 1970s. I don't dispute that from the late 1970s, the whole thing begins to fall to pieces, but I'm quite keen to push research into why that happens. It is definitely a two-stage process, and there's been a much more rapid decline since 1990 than there was between 1977 and 1990. One of the key issues that we need to take, somebody needs to help us understand is why the National Union of Mine Workers hasn't had more of an influence on the infrastructures of occupational disease between 1990 and the present. And one of the reasons is that NUM has its mind on other things. So if you go back and look at what they were worried about, they're really preoccupied with underground safety. This is best captured actually by Jean Lejeur's excellent work on trying to get the mine managers to take workers' sense of underground conditions much more seriously. But mining is extremely dangerous in South Africa, as you all know. And it's mainly in this period, the mines are preoccupied with rock bursts because of the depth of the mining and the danger of working at 3,000 meters below the surface. But it's also pretty striking that the NUM moves with really alacrity into what we could call the domain of financialization. That's the pension funds in particular, and the other funds that were investment funds that were derived from the pension investments in the NUM. This is a period in which the NUM produces two presidents, right? So Motlanthe and Ramaphosa are both former Secretary Generals of the Union, and two really powerful cabinet ministers. And yet in that period, the occupational health infrastructure clearly disintegrates. So it falls to pieces between 1990 and the point at which Barry Kitsasavi takes over in 2012. It's not possible. The conventional argument that's used for this is that this is because these racist institutions existed before that made no provision for African workers. But that is in many respects the opposite of what was actually historically the case, which is that we had a very capacious system, which was incredibly stingy. It didn't provide people with what they probably deserved, but it was systematic. And yet, so the system, it's pretty clear. The public system, with the assistance of the mines, begins to repair after 2012. And at the same time as that public system is being repaired, we begin to move towards the trusts, right? So, and the big fact that no one's mentioned, and which is really an important takeaway from Albert's PhD and the PC, the excellent paper he has in JSAS, is these trusts are funded by mining companies that are leaving the country, right? Please just think about that for a second. So Gencor makes its contribution to the asbestos trust, and then it buggers off to Australia. Anglo Gold abandons deep level labor intensive mining. It doesn't actually, Anglo Gold, right, which is in many respects the South African economy in the 1970s, no longer actually mines gold in the ground in South Africa. It has some open pit mines on the rest of the continent, but otherwise what it's doing is contributing to these trusts and leaving the country. And I think we have to be very careful about seeing this kind of what we could call political settlement as, in the long run, a really serious way of managing this problem. Gold is back at, $1 million a kilogram, maybe a little bit less. It's declining at the moment. People are going to mine gold. The question is, how do they do it? Are they going to mine it informally, or will we have actually regulated government, companies that do it properly, and which we fund it properly? So I would say I'm skeptical. I'd like to see a really careful study of how the trusts are finding beneficiaries. I think this is going to be much more difficult given the informational weaknesses that exist in the public domain. I'm worried about what we could call the real health burden of mining, which is, it seems, primarily tuberculosis treatment immediately after people leave the mines, right? So what provision is there going to be for building a rural infrastructure that will provide people with the care that they need, primarily for tuberculosis, in the first 5 years after leaving mining? How do the trusts help us with that? And the third, and my dogs are about to go crazy, the third and really important point is whether the trusts can in any way strengthen the existing public institutions, right? The compensation infrastructure, which in my view has to actually continue to function. I think there's a real tension, and I'm sorry, Richard, to say this. I know it's basically grounds for accusations of high treason. It feels to me like there's a profound contradiction between the constitutional order that the law and the courts are implementing and the actual institutions that exist in South Africa. My favorite example of this is, the constitutional court killing Net1, which was doing a pretty good job of distributing grants and allocating it to a post office that can, clearly not pay rents in most of the towns in which it actually has to distribute grants. Okay, I'll stop and I'll take comments and maybe have a chance to complicate and make my arguments a bit more sophisticated.
Okay, thanks so much, Keith. We've got some very rich issues for debate, and I'm sure there'll be agreement and disagreement. So, Keith, could you just screen share your screen because you're still up? And I see Rodney has a hand up, May had a hand up. I'm just checking who else wants to say something in this round. We'll take 3 or 4 comments. So in the meanwhile, May, you're up first.
Thank you very much. I'm actually standing in a parking lot listening to all of this while I'm waiting for some processes to be followed. So just excuse me that I can't turn on my screen so you can see me. But I just wanted to add some comments to in line with what Keith has just shared. So for me, there are a couple of things that I want to clarify. I want this particular audience to think about is the move from prescriptive legislation to legislation which is outcomes based, which essentially is risk management based. And I'm sure that I missed Robert Vivian's input, so he might have something to say about that. So for me, there are 2 issues here. One is the advantages of prescriptive legislation, even though there's often a lag between what is cutting edge practice and what is best practice, is that it captures practice at some point in time, best practice at some point in time. At the moment, we don't have the means to actually capture this best practice for 2 reasons. One is we can't capture it in law because it's now every company has to look for best practice in and of itself. And if you're aware of the training of engineers and technologists, they come through essentially a significant process of learning on the basis of experiential learning, where they build on what others have done in the past. So we've removed that pillar from technological learning in mining. So the other matter is, if one looks at what the department has done through the Mine Health and Safety Council to compensate for this, is to produce guidelines. And if one looks at the current number of guidelines, you'd be astonished at how much there is, and the difficulty in accessing all of those guidelines. In fact, the guidelines in and of themselves, at the last count to me, looked like they covered over 1,000 pages of guidelines, and they're not all there, and it's in a fairly fine print that one of the key major legal firms in the country have put together. So insofar as being able to institute risk management measures, it's very difficult when there is no institutional memory in our regulation. And we also have the situation where companies change hands all the time. They change hands a lot faster than they do all of the departures from South Africa, both in terms of major companies and all of the infrastructure that they had around them in terms of technical know-how, as well as the fact that young engineers who are entering the sector now no longer have access to the experience of engineers who were involved in some of the major work and major innovations in the sector. So there's a loss of memory. I think that in the technical environments, particularly, we are going to see a major problem, not only in mining, but across industries that are ultimately labor intensive and which require sophisticated means of production. That's the one point.
May, I'm going to have to ask you to be a bit concise. Okay.
All right. I think let me just leave that there then. But I think the key concern for me is that there are wider things happening in the environment. I think the issue about a global wage is going to become critical in the future, mainly because no company that is exposed to the level of risk in an operational environment, to the extent that our gold mining companies are going to be willing to put people into their workplaces, which is why we see this drive towards modernization, automation, etc. So I'll leave it there. Thank you.
Okay, I've got Rodney, Barry, Sophie. Rodney, over to you.
Good afternoon, everybody. Thanks for this debate, which I wished we'd started some time back. The American academic Nick Ashford, I heard him once say, in regard to asbestos, litigation is a bad idea whose time has come. And in South Africa, you could say it's been coming for a long time. You know, I wish I could, the argument put by our colleagues, Dr. Mushai and Professor Vivian, I think it's conceptually strong, but it might be an abstraction too far. From my perspective, having been clients of these two systems for the last 30 years. I just want to focus on the question of the sort of exceptionalism of the ODIMWA system. And I think what we have in the early part of the century are two systems, the Workmen's Compensation Act, which started about the same time, but the mining system developed its own negotiated system, really the White Mine Workers Union. And these points have been mentioned, but you're dealing with a system, first of all, with long latent disease, not accidents. Secondly, a migrant system. Thirdly, a system where up to eventually 50% of the employees are coming from other countries. All managed, I think, on a political basis within the colonial system, and then the apartheid system, and now somewhat falling apart in the post-apartheid system. So I think I agree with Keith. Well, I disagree with him. It's going to take more than a workshop, but I agree with you implicitly in your view that we need to understand the history and what it takes for a workforce or a population of miners to get the full cost of their injuries or disease paid. I think it just seems to rely entirely on the statutory system at the moment, as I say, just seems a long way off. And I think trusts have, I wouldn't call them a bad idea, but they're certainly an idea whose time had come. But I leave it to others who might be more optimistic. Thank you.
Okay, thanks, Rodney. Barry, and then Sophie.
No, thanks. And I'm hoping to pick up with some of the colleagues, at least from WITS afterwards, because I've been trying to seek out quite a bit of inputs. But very quickly, so the interesting thing was the question I asked yesterday was that you had the Rand Mutual Assurance Company coming into being in 1894, thereabouts. And why did we have to create a separate system for occupational diseases if you had a mine-owned insurance agency that's in operation? And why do you bring in a statutory provision in 1912? And one of the key areas which led to the ultimate demise of the entire thing was the 1973 input. So basically, it's fallen apart since then. Historically, African workers in particular were not really covered by it, albeit in terms of the varying issues with the provision. So there was so the first question is, why is it that you had a Rand Mutual system in place, and why didn't this system go as a subcomponent of Rand Mutual? And essentially, I've argued that this was a socialist system for whites, essentially from 1912 to 1973, where the red ticket examination. So the compensation system was one part of an entire preventive, promotive, periodic, exit, and cradle to grave assessment of white mine workers. So I go back in the early work. You wanted a fitness certificate, you needed to come to either Braamfontein, Witbank, or Welkom, the sub-bureaus. And part of the process was, and of course, African workers had to go to Selby through the TABA system in terms of the process. So the system, in terms of the Odumwa process, in terms of the original act, it actually set up the entire system, which was the fitness examination, which ultimately got decentralized. So that's the first aspect. And the state was heavily involved, including the £100,000 seed funding for the compensation fund. Now, that was never given to Rand Mutual. So the state basically has cross-subsidized the mining industry considerably from 1912 when the act was set up. The sanatorium that was put up for miners' thesis for the white workers in Modderfontein was 20 acres of land donated by the Smuts government at that stage. So there's a whole history behind the issue about how is it that this fund functioned well up to a certain point and then collapsed in its entirety. And I'd like to pick that up with Keith and other colleagues. So that's the first part of the process. The second part was the famous 1973 Act says quite clearly, a practitioner in the Republic of South Africa. So my minister, Motsoleri, when I came in, was gobsmacked when he had to realize that he had to provide services under voted funds in Botswana, Lesotho, Mozambique, Eswatini, etc. He never knew that a health department had to provide service out of country. So if you take the 1973 Act, we also did not have to provide services in TBVC. And in fact, there was a separate compensation system for about 50 million Rand nested in this compensation system for what was then called Transkeian workers. And I had to manage that process from about 2007, where we had to, give out certain sums to ex-Eastern Cape mine workers in terms of the special Transkei dispensation. The only thing, Keith, is the deferred fund payment. There is another body of thought which said that black workers paid for their own oppression through the deferred fund scheme through TABA, and that continues up to today. And I think something that we have to tackle about where up to 30 to 40% of your money is kept back in terms of the process. The interest paid for the KD Matanzima Airport, the interest paid for the judicial system, the interest paid, yes, for hospitals, but in a sense, it paid for the oppressive regimes, particularly in the labor sending areas, euphemistically. So let me just conclude on the last part, which is setting up the parallel systems of trust. I argued that extensively when the Asbestos Leaf Trust and the Quebecer Trust were set up. These were set up in parallel. There was no interactions between those trusts and the statutory system. And until I made a breakthrough with Richard Spoor, which said, Richard, I know we've collapsed the system and the mining companies, and hence I have a seat on the Shiamiso Trust. So it's the first trust which actually heard the call, which said that can we renew the statutory system, which would outlive the 10 years of the Shiamiso Trust. and actually bring about a thing. And we currently discussing what would be an integrated model. So we essentially have set up a parallel system as opposed to strengthening the original system and taking it forward. But I'd like to continue this discussion outside of the meeting. And Richard, you know, we tried the process of integration of the compensation systems. There's a 1999 cabinet resolution to integrate Mine Health and Safety Act and Occupational Health and Safety Act and the two compensation systems. Because it's crazy in a country. I've yet to see, there's quite a few other regimes that we worked with where you have a completely parallel inspectorate, parallel system, as opposed to saying we could have a mining subsection, a chemical subsection for chemicals, we could have an agricultural subsection. So there's a wider political debate, which hopefully if we can get over the statutory issues of rescuing this 5 billion Rand compensation fund, which I currently run with some of the other colleagues, that we can actually get on with a better dispensation for workers. Over.
Thanks, Barry. Sophie, you the last comment, and then we're going to go back to the panel. Sophie?
Yeah. Thanks very much for this very interesting discussion. I think that we need to focus more on the solution. We do need a better compensation system. And as Richard very clearly said, the trusts were never meant to be an alternative to a system, but I think to a large extent, a way of redress. What is missing for me in the discussion, partially missing, is the actual humanitarian approach, the human fallout of the failure of the systems, and what it has left us, what it has left behind over in Southern Africa. If you look at the social security systems in Europe that came into being after the Second World War, it's remarkable how they are functioning in many of those countries today and how integrated they are with regards to compensation for occupational injuries and diseases and so on. And why do we find it so difficult? And I think that our academic institutions are not helping us through research or to guide research towards solutions. What system could work for South Africa? Because when we try to find solutions, it's not inclusive, it's not transparent, it is too hierarchical, too controlled, too prescriptive. So I think it is important that we need to discuss it. And Leslie and all, thank you very much for starting this process. I think a discussion on all these things is important, but not one position holds a particular truth. It's all the accuracy of the history that informs the future, but we need to pay more attention to the research that will really help inform the future, and not just try to implement another problem that will make workers suffer forever and forever as we go forward. Thank you.
Okay, thanks, Sophie. I think every speaker has the point about workers suffering, the purpose of trying to have a system which relieves that suffering. I'm going to ask Albert to respond because you put up your hand, and maybe you could have the first response, and then Robert, Richard, and Keith. Albert, over to you.
Yes, thank you very much, Chair. I just want to touch on a few things that have come up as a result of this discussion. And Richard has actually touched on a number of crucial issues. And the more I listened to him, the more I realized that the points of agreement are actually much more than those of disagreement. Occupational risks are problematic in the sense that a greater proportion of them are actually hazards of industry, as Richard pointed out, to the extent that you can deploy the judicial system, the liability rules as they stand, and you are not going to get anywhere. So that point is very, very important. But more crucially, I think we should not shy away from looking at the stakeholders in all this, especially under the workmen's compensation framework. The stakeholders are essentially three: labor, government, and employers. And to some extent, you can find that there are different levels of blame that we can attribute to all of them. Government, as the underwriter of the system, actually has the responsibility of ensuring that the system delivers in terms of expectations as it is governing. It is government which is supposed to be governing, and it must constantly adjust the system to make sure that it is responsive to the changing circumstances and living conditions of workers. Employers, on their part, they too are a stakeholder to the extent that they need to advise the government where they see things are not going well. You cannot tell anyone that a system that ends up paying a worker who has worked for 16 years as an underground rock driller, and they end up paying him 16,320 Rand as full and final compensation is just. There's simply no way. But employers were presiding over that system. They could have said, roped in the government and say, guys, let's look at this thing. We don't think it is. So that aspect of the role that individual stakeholders have played in the plight of silicosis sufferers is actually important and needs to be considered. The system has very weak incentives for preventing accidents. And when that happens, you link it to poor benefits, accidents are just persisting. At the end of the day, you are going to have an alternative emerging. It's inevitable. Okay. So there are excellent proposals that have been made. I've read one of Rodney's publications on prospects of reforming the system. Very interesting arguments there. But like Richard says, the political will may not be there. And if it is not there, we are not going anywhere. Thank you very much, Chair.
I'm muted. Thanks, Albert. Robert, I don't know if you want to add anything.
Yeah, I just want to add one small thing which May made and Richard was also making. May, lovely to hear from you again. And that is the idea that somehow risk management has replaced the sort of regulatory system. That was never the intention. The original regulatory system, you simply had regulations, and the chances are they would never get implemented because there was no system behind them. So the idea of risk management was to have a managerial system which will implement the regulations. I actually, in the first textbook I wrote, I had a section, I took it out afterwards because nobody did it. It's what I call statutory risk control. And that was to take the different regulations and then make sure you have a system to implement those regulations. So the idea that risk management has replaced regulatory system is really not the original idea. The original idea was to find a way to implement these regulations. And May, you're quite right on the point, except your numbers are quite small. When the financial crisis took place in London, the governor of the central bank wanted to know what regulations had been put in place for preventing this type of thing. So he sent one of his staff over to the Financial Services Authority. They came back and said, oh, there's over 10,000 pages of guidelines. So there are 10,000 pages of guidelines. But in fact, there wasn't a single regulation which dealt with the matter which caused the collapse of the financial system. So I think you raised a very important issue, and I think that we should put the risk management system back in the correct place. We have rules which we have to comply, but the rules by themselves will not get implemented, so you need a system behind that. But the system does not replace the regulatory system. I think it's quite important to put that system back into place because it's got lost somewhere along the line. Thanks a lot. Thanks, mate. Good comment.
Thanks, Robert. Richard, do you want to pick up on this? Do we really have a bad idea whose time has come?
Yeah, thanks. Perhaps just, on Robert's comments about, the risk management being intended to kind of provide a supervising structure for a regulatory framework. One of the problems of the regulatory framework is there's no independent state capacity to enforce it. So the decline in state capacity is a major problem. So, I mean, what are the examples? You find no prosecutions, no successful prosecutions for breach of the primary statutory duties laid out in the Mine Health and Safety Act and the Occupational Health and Safety Act, because the state, its inspectors and the prosecutors who work with them, don't know how to litigate these kinds of things. They don't know how to prosecute these offences. They can't enforce them. They have no insight how an oil refinery works, or a mine, or a steel factory. So there's a problem with capacity. But mainly I wanted to just respond on the question of law reform and reforming the compensation regime. The pressure to do it is coming from the collapse of the statutory schemes. So the compensation fund's performance, which administers the COID Act, continues to decline. A few years ago, we saw the handover, lock, stock and barrel, of steel workers from the fund to Rand Mutual. One reason for this is because the fund was incapable of managing this volume of claims and the issues arising from it. So you give it to a private insurer, or in fact a mutual insurer like Rand Mutual, because they can do the job more effectively. Then there are other incentives that are driving talk about reform, and one of them is privatization. So the latest amendment bill on changes to the COIDA provides for the scrapping of this provision of mutual insurers. And it looks as if this is set up for the introduction of private insurance into the scheme. So there will be competition for Federated Employers Mutual and for Rand Mutual. In fact, what appears to be on the cards is a privatization of Rand Mutual. It looks as if financial institutions are setting up themselves up to take over this very valuable business and do a BE deal in there and privatize the whole thing. And that seems to be something that's happening behind the scenes. There's nothing wrong with the idea of private insurance. In fact, if you think about how might we reform the system, well, one of the easiest ways to do it would simply to have a law that stipulates that employers should obtain insurance for a range of for the full spectrum of injuries and diseases, and stipulate the minimum benefits that they should insure for. I'm sure a system like that would work better than what we have now. So there's scope for it, but the agenda that's driving reform at the moment is suspicious. It's driven by collapse and I think commercial self-interest. Fixing COIDA by some kind of reform is a lot easier because it's effectively provides short-term insurance, principally for accidents. Fixing a DIMWA, and one of the proposals that was on the table is to merge a DIMWA with a COIDA, is simply impracticable. So a DIMWA is not short-term insurance. It's effectively life assurance, long-term insurance. And the funding models are completely different. The one you do on historical risk, that's for accidents. You look at their risk, their claims record, and you adjust your premiums accordingly. With a DIMWA and lung diseases and dust-related lung diseases in particular, the model has to be you've got to predict how many cases you're going to get, and you've got to fund that from day one while the worker is still healthy, which is why we have this risk levy. You know, you contribute towards the fund from every for every shift. But you do those calculations based on a payout. So you anticipate we're going to pay out 130,000 Rand to every worker, and you begin saving for that 20 years early. There is no way of increasing the DIMWA benefits because there's a massive funding shortfall. That funding shortfall can't be recovered from employers today because, as somebody pointed out, I think right from the outset, you know, these diseases arise from conditions and employers 20, 30 years who don't exist any longer. You cannot expect current employers to fund that massive liability. And it means you cannot increase their DIMWA benefit without finding that funding. And the only source of possible funding is the state. And the state doesn't have the money to top it up. So in terms of a DIMWA, we do not have the ability to improve the benefits under that scheme unless the state comes to the party in a very, very substantial way. And there is no other way of putting them together. I believe that part of the idea is putting this liability, this ADIMWA liability, handing that over to current employers and spreading it across the workers. So the mining industry quite likes the idea that every mom and pop shop and every business should pay increased contributions to the compensation fund to make up this ADIMWA shortfall. And it's something that needs to be guarded against. We need to be clear who's going to fund the shortfall. If you want to improve the benefits, there's a shortfall, how are we going to fund it? And you can't fund it, well, you could try and pass it on to other employers, but that is a big bun seller for some people and enormous cost for others. So the reform is the critical issue that we've got to be looking to. How do we fix these systems? And you know, to drive that process, you need a willingness. Unfortunately, to date, and this continues to be the case, the primary driver of reform is litigation by lawyers such as ourselves, who are attacking the system, identifying the weaknesses, and measuring them up against constitutional standards. So we are looking to attack and bring down the system because it's not compliant with the basic kind of standards that the Constitution demands from us. So we're looking aggressively at the meat chart and the way that compensation is calculated, and aggressively at another massive issue, hearing loss, and the way that people are compensated for hearing loss. And it's our view and our kind of long-term strategy, just one thing, is to force reform by continually putting the system under pressure until there's a wider recognition and acceptance of the need for us to begin again and design something that actually works. Thank you.
Thanks, Rich. Keith, any comments from your side?
You know, I don't have much to say. I would say to answer Barry's question, 2 points that I think are really worth holding on to. The one is that the system was much more extensive for African workers than people tend to want to acknowledge in this discussion. So it's pretty remarkable that the state was basically stipulating compensation payments for tuberculosis for African workers from over a century ago. And that creates a set of institutions we can't easily back away from. If you study economic history, you'll see you don't get to choose your institutions. You inherit them from the depth of time. And the question we really have to face here is whether we trash these ones and whether we have any possibility of creating new ones. So the reason that we have a kind of nationalized compensation system from 1912 is because the white workers were holding the state by the throat. You'll know this. There were 3 really life-threatening strikes, including very touch and go, that we were the third Soviet republic in 1922. So the state intervening is to basically kind of dampen down and guarantee that there was some goodies for white workers. But African workers got something out of it. It wasn't a void. And if we keep talking about it as a void, then we have a real trouble dealing with what we have now. The second point I would say is that there are many different kinds of suffering. And one of the things that I would say is happening on the Highveld that people don't want to talk about is that there's kind of institutional deformalization across the whole urban infrastructure. That as companies fail, mines fail, municipalities fail, infrastructures fail, and workers, basically, people are taking on kind of life-sustaining economic activities of any kind. So if you walk around in Johannesburg, you on a normal day will see thousands of people harvesting waste up the railways, up the roads in the wrong direction. No one intervenes and says, hang on, you're putting your life at risk here. There's no state actually to stop that. And for me, that's the imperative, is what will strengthen the formalization of care. It's what the social scientists call biopolitics. And I can't see a privatized, we really have to say that in some way we have to find instruments that are going to strengthen how the state regulates. And we can't keep pessimistically arguing that the state has no capacity and it's never likely to have any. And that's an even more serious problem if you go to what we call the labor sending area. So you go to somewhere like Lusikisiki, there are new hospitals, brand new hospitals that the state has built that have no staff. That's the real issue. It's not framing this, I'm afraid, in legal terms as being about natural justice that afflicts individuals, only paying 16,000 Rand to someone who's worked for 20 years. that it completely avoids, it steps aside from the issue of how we build a set of infrastructures that are going to take care of the people that actually live in this country. If we don't do that, what we have is, essentially massive unemployment, no healthcare, and no prospects for people in the future. And that's the only way I can see making that work is to treat the mines as a sort of ally, extract the resources we need from them, but to fund something that's going to take care of more people than the current situation does.
Okay, thanks, Keith. We've had a good round of questions. We're going to take maybe just one or two other comments because we're almost up. It strikes me that, I'm going to jump in. It strikes me that we all agree we need to fix the system. I mean, nobody disagrees with that. But I think the starting point of this whole discussion was whether the court-ordered trusts help us or hinder us. And it strikes me that if we have litigation, I mean, shouldn't we be having litigation to actually strengthen institutions rather than achieve the justice we want for individual workers or groups of workers? But we should be using litigation to push the state to create sustainable institutions, should we not? Can I toss that into the pot as a last comment and see if anybody wants to respond to that?
Leslie, I'd like to pick up on that. It's May here. I absolutely think we need to do some thinking about that. And the points that Albert was trying to make earlier is that the compensation system is nested in a very complex system that supports our society. So I'm with Ken on a number of these issues. I think that at the moment we're in danger of trying to achieve changes when in fact the entire system is shifting underneath our feet and somehow or other we're not keeping it in line of sight. That's all I want to say. Thanks.
Barry?
No, at a policy debate level, we've got major issues that are affecting us in terms of the public health system. In my discussions with the provinces and the neighboring countries since I came on board in 2012, is the issue around what's called an unfunded mandate. The state system at the moment says the burden has been caused by the mining sector, and why do we have to pick up the burden of sorting out the problem? So I like Keith's point. I mean, that's what I've tried to do is alignment of the mining colleagues together with the issues, and ultimately I hear Richard's point, and I'm really sad to say, but that's the reality. We've tried within the state infrastructure to try and provide the support, but it's seen as an unfunded mandate. We've experimented with new decentralized services. Historically, mine workers had to come from Shashai and Dusiki to Joburg to get a simple chest X-ray when there's a whole lot of hospitals close to them. But it's something that we need to discuss, and I'm not too sure in terms of convenership. Leslie, you've started off the process, and I'm very keen on a discourse about this. And the last issue is a fundamental issue. Is the cost of prevention going to be greater than the cost of compensation? I'd argue that the cost of compensation was lower than the cost of prevention, because up to now, the OEL, which I've argued at great length on the 0.1 milligram per cubic meter, what do we have is a milestone which says 0.05 by the year 2024. And then we have a different agenda which says that Gavin Churchard's work in 2002, funded by SIMREC, says that 0.05 milligrams per cubic meter is not protective. So the fundamental issues is that we've got it wrong. If the cost of compensation and picking up some of these social justice issues, 20,000, 500,000, 2% of the population, then we've lost the plot in terms of the cost of compensation versus the cost of prevention. So yeah, we look forward to it. But unfortunately, the state apparatus at the moment says this is an unfunded mandate for those that have worked in the public service. Over.
All right, so I think this is the start of a conversation. It's not a conversation that I initiated, other than to read the article and think, hey, that's a really interesting article and maybe we should talk about it. I was asked to chair this because I actually have no direct involvement in any of the court cases, but I'm happy to have chaired this. I think Sophie's call on academic institutions to step up to the plate and assist in finding solutions should ring with us. And I'm going to close it with the suggestion that we've all started this discussion. It's a complex issue. We agree on the principles, but getting there might take a lot of detailed conceptualization and rethinking and discussion. And I want to thank all the speakers for really, really interesting inputs, making their time available, and for everyone who stayed on this meeting for an hour and a half. I hope to see you soon on another discussion and hopefully take this a bit further forward. Thanks very much.
So the colleagues.
Okay, thanks everybody. We're going to shut down now. Thanks.